Welcome to Module 5 and Week 10. During this first lecture of this module, we're going to be covering Week 10, and within this lecture we will be discussing liability and the sale of food and the liability in the sale of alcohol. So again, a couple of terms we need to take into consideration. We have a set of rules that is designed to simplify and modernize the law that is governing the sale of food and the sale of goods, including the food in our case. That is called Uniform Commercial Code. Another term that you have not seen so far within our studies is merchantable. That is the implied warranty that refers to the sales of goods, including food, and establishes a standard of average quality that requires, that the food fits within their ordinary purpose. We also have something called the foreign or natural substance test. That is a test that seeks for foreign objects and ensures that what the food is supposed to be is what the food is. Existence of foreign object will actually imply a breach of contract. Okay. A reasonable expectation test. So that is a test that examines whether an object found in the food could have been anticipated by the consumer or it is fully unexpected. Okay. So if the object could not have been foreseen that it will be there, ultimately that will be a breach of contract. On page 491, I did notate within this chapter Webster v. Blue Ship Tea Room. So the Webster family was in the tea room, and the lady wanted to eat clam chowder. Clam chowder ultimately was an item that was no longer available, so she decided to go with a fish soup. Obviously, she went through the process of consuming the soup and ultimately felt something in her throat. She went to the doctor once, and the doctor didn't find anything. She went for a second procedure, and ultimately during second procedure, a fish bone was taken out of her throat. So again, that is an object that should not have been there and ultimately caused a breach of contract. If you're eating fish soup or any other thing, it needs to be free of foreign objects. Another term that we have discussed in the past, but whenever the issue is big enough and the loss suffered is from more than one person, maybe all the people together could decide and go for a class action lawsuits. So the whole group of people suffered the same consequences, and they decide to litigate the case all together. Privity of contract. So whenever I purchase something and I pay for it, we have a contractual agreement with me as the purchaser and the facility from which I purchase it. What I wanted to notate here is this. So I have different rights if I paid for that meal directly or if I was a guest for a wedding. Whenever I'm a guest for a wedding, ultimately a privity of contract rule does not exist because I did not pay for any of it. Strict product liability, that's the doctrine that imposes liability on the seller as it pertains to a defective product. So in order for this to exist, a couple of things need to exist. The defendant need to have sold a product that was in a defective condition, rotten food, item that was not in a healthy condition. Then the plaintiff, the person that received the item or consumed the item, needs to prove that they were injured as a cause of that unhealthy item. And then 3, the injury was caused, as I mentioned, by that defect. Okay. The next thing that I wanted to discuss is the following chapter, which is liability as it pertains to alcohol. There are a couple of things that I have notated here as most important that you need to be aware of. Obviously, a full review of the chapter will be required, but I wanted to kind of pinpoint some things that you might have heard in the past. First, no facility or no business could sell alcohol without having the proper liquor licenses first. In reality, you should know this already, but I'm sure you have seen those signs all over the place. We cannot serve alcohol to people that are underaged, and the hot topic age is the age of 21. Then the other people to whom we cannot serve alcohol, even though they're above 21, is people that are visibly intoxicated or people that are habitual drinkers. And we are aware of them being habitual drinkers. If you don't know, you can prevent. But courts have proven if you know that they're habitual drinkers and you serve them anyways, then you become a negligent person. Now, for visibly intoxicated people, we have a couple of rules, and the rule is, if I have served you 3 drinks or 5 drinks or 10 drinks, that is not the test for visible intoxication. So slurred speech, movement of the body, things of that nature are taken into consideration. And why do we say that? Because maybe I could have the effects of a drunk person only after 1 drink. Meaning the courts recognize that each person can consume different amount of or a different quantity of liquor prior to them appearing impaired or visibly intoxicated. But for the purposes of this, that is a person whose appearance or actions indicate that he or she is intoxicated, and sell alcohol to a person like that, be ready for a negligence case should something happen. And dram shop liability is the hot topic here. So with Dram Shop Act, that is a statute that keeps the seller accountable for the actions of the person that consumed. So meaning, if I sell to a person that is under 21, a person that's intoxicated, a habitual drinker, or I serve to somebody that does something that causes a bodily harm, I am responsible to the third person. There are some states that do not have a Dram Shop Act, and that is the first one, the most famous one. That's why I put it as first, is Nevada. Then others that are also not covering or do not have Dram Shop Acts are Kansas, Maryland, Nebraska, South Dakota, and Virginia. Every business that serves alcohol needs to have a liquor liability insurance, and that is an insurance that is purchased by the liquor licensee in order to protect the dram shop liability. So people that have worked in restaurants, maybe some of you guys have worked in restaurants and bartended or know how the food and beverage industry works. So associates that serve both alcohol and food need to be certified, certain trainings need to be passed, certain education needs to be happening in order to ensure that you're not seen as a negligent person. So there is a difference when it's an honest mistake because we didn't realize or we didn't see, and there is a difference whenever we were poorly trained. So poor training usually keeps 100% negligence on the forefront for that business.